watching very few people who are going into sleep. So it was very interesting, and people were looking at. Rob. Yes, yes, but I have seen very few people who are, because we can see from here very rightly, except one or two was dozing off, others were really very attentive. I know that one or two who are they, but no, I'm not going to say that. I really don't know whether they're dozing off or they are very concentratedly, they were hearing a high amount of concentration. Maybe in a state of yoga, having a better thing. No, it was very interesting. Now I need to sort of sum it up, not really giving a summary of what they said, I think, which you understood very well. I think I need to sort of something relate with the Indian Patent Office and the Indian system. The patent prosecution highway, for example, the US and Japan has been sort of interacting with us. I have attended some of their yearly meeting, one of the yearly meeting in Geneva, where this idea was first presented to the countries. 10, 12 of us were there. We heard it, and idea-wise it is good. But you know, this is a problem. I sometimes feel that this is possible mostly between countries which have a considerable number of applications comparatively. Now, Office of First Filing in India, you have international application filing today is at 1,500. Last year it was 1,200, this year it's around 1,500 PCT applications filed here. And the convention application also, if you are to US, let us say, these two applications may be around 1,500, whereas we receive 16 to 70,000 from US as first filing. Or let us say the PCT route also if you take. Now there what happens is we will remain always as an office of second filing. We will not be a comparable office of first filing. This is one reason which we will not be able to join, because we will not be able to give our results to them. We will be always receiving results from other office. Now the other issue which I think I made once clear to Mr. Kapoor, I wrote a reply to him, saying that our main issue of delay is, you know, lack of manpower, which we add up now. Our delay will not be there. If you add up by 260 more, by 2015 we will have only a year and a half of delay. And the next stage of recruitment we are planning for 2016 to take care of the increased number by that time. So that is the first solution that we would like to offer. And the legal system difference also we should understand. Everything you cannot. Now this presentation regarding business ideas, software made in Bangalore has a great sense, because Bangalore is the innovation center where these type of innovations are being done. And most of them, as existing law today, is not patentable in India. That's our law, and nobody has actually challenged. Morning I was hearing Lakshmi Kumaran speaking, saying that there's a small point in using per se. Yes, there's an opportunity to be tried in a court of law. Let's try that. I mean, somebody should try. But at the same time, we have refused a few patents. Software applications are saying that either as a pure business method or as a pure software. Not a single applicant has gone in appeal against that to the appellate board, against the refusal of those patents. Same is the case. I mean, the comparative refusals were less. None of these refusals were appealed against for getting this grant, which I believe, you see, somebody will say that why did you write? A lot of correspondence I had from people. In fact, Lakshmi Kumaran has written that I should interpret in the manual that business method per se is not patentable, mathematical method per se is not patentable, computer software per se is not patentable. I opted for the other because that is our position. And with that position, we took decisions which has not been challenged in the court of law. I replied to, I think I spoke to Lakshmi Kumaran, you try it in the court, let's build laws in this country. US strong litigation has been strong. US patent is 320 years old now. 320, 1792, 321 years old now. And litigation has gone up that much. We have 100 years of history, but number of litigation is minuscule even today. The all patent cases, if you take an infringement case which went up to High Court and above, is minuscule. So we need to further develop this law. Very few litigations are coming, even though it is very cheap when compared to India. Strong litigations are not coming at all. In the last 2 years, or against a refusal, there is not a single case. Only on procedural issue there were cases. Litigations which are happening based on procedure, basically something like arbitrary decisions of my patent offices. There used to be people go with the writ to the High Court, and they remanded saying that reconsider. Not on point of patentability, only on procedural issues. And after we made a lot of clarification and manual, these procedural cases have also come down. Now we actually need cases on point of interpretation of law. There are only very few coming to the higher courts. We need more of them to come. Now I expect this to come in coming 3-4 years, where the patenting and litigation and enforcement is going to be very strong. The other part of enforcement which we have not talked about is the the customs procedure, custom people trying to enforce. There are very few companies even now registered with customs for them to prevent the import of infringed material, both in trademark, patent, design or GI. Very few people got registered with customs so that they get fast approach and prevent this thing. That I think that exercise is going on. I think I would agree with Robert saying that we have a big educative process for enforcement. Enforcement is not a part of the Indian Patent Office like you have. Enforcement is left to the court, the police and the customs. These are the three agencies who involved in the litigation process. But I would always say every IP office is the first part of enforcement. Like that is where they were saying the claims, drafting and granting a patent with an enforceable claim. And on that front, in last 2 years of my experience shows that neither our attorneys nor my examiners are very strong enough on this to really grant patents with an enforceable claims. And many of those are going because drafting needs tremendous improvement, and the type of objection the office raises about those claims, the way it is written, is not grantable. It doesn't actually dispose. It's not really, the scope is limited. The Patent Act needs succinct claims to be made, succinct. But the claims are so long which does not really enforceable in law. So there is a tremendous amount of improvement needed in the Indian patent, both in my office by way of training and the attorneys by way of practice. The reason by which they are going ahead with this, in the litigation, this is not challenged in the way what Mr. Sharma was saying in the US it is done. On the language of the claim, challenges are not happening. And in short time to come, such challenges are going to come in litigation in India. So the drafting of the claim is very important. I know one company, one person is sitting here, they are drafting, created a big litigation now. I don't know what music they are going to face. Simply the drafting. It came back to the patent office to give the opinion. It has come back. This is almost 19-year-old patent. It's going to end in 2-3 months' time. The litigation is now at the final stage. So it's possible on the drafting side. The enforcement needs to be strong. The drafting has to be strong. There needs a tremendous improvement needed in this country. US, this has become a big question. Now, another thing, the Indian law very specifically doesn't say about the point which Anand said about the, you disclosing the prior art. There are a few very senior patent lawyers in this country. In their application, they never mention a prior art, because our law expressly does not ask that in the application there should be a mention of prior art. But in order to make a better understanding for the examiner, it's always better. But there it is caught, saying that is a question of invalidation. If knowing prior art is not mentioned intentionally, kept secret, is an issue of invalidity. Our law doesn't have that. Theirs is much stricter in that way. The prosecution system is much stricter in US than what it is. The only thing which is different I find is we have a compliance report in the form of Form 27 about working of patents, which the US doesn't have. And when I tried to enforce that part of it, there was a big hue and cry. There was a big hue and cry. But last year, out of 33 or 35,000 patents we had enforced, 24,000 people submitted that return. And my office is not going to scrutinize that return, whether everything written there is correct or not. That's the first thing requirement. That requirement basically is meant for the compulsory licensing aspect of it, and also for a statistical purpose to know that the granted patent is working or not. The country's requirement, especially for a developing countries, to know the technologies which has come patented is really being worked in India and whether it is contributing to the growth of this country. That's why it has become part of the law. That enforcement they took very seriously. Robert, your Assistant Secretary of Trade, who was part of your patent office, she landed immediately in protecting all the US interests. US interest is saying that it's very difficult to file this. This return takes $500. Some information has to be given. Maybe The lawyers charge very high. I don't know the information just to sign and send it here, they would have charged long. But I said it's a very simple thing. The same law which granted you the patent, the same law which gave you the patent right, demands you to give this information every year. It doesn't cost you. In these days of internet, in these days of computer technology, every company who has applied for a patent has the details in their computer about the sale of a product or commercialized or not. But that, of course, I think this year more number has come. And to make it more transparent, we are in the process of digitizing all those forms, and we will give it to the public. Let the public of this country know. So there is a tremendous difference between always when you compare these two countries. We are, of course, developing, we are growing very fast, but there is a hell of a difference. We have less than $2 a day earning people. How many of them? It's around 50 crores, maybe 500 million people are there of that sort. So their interest also has to be kept. That's why morning you look at the 3K. In the interim, in 2005, when it came 2004 and as an ordinance, there was something like your transformation. You had the technical effect like the EU regulation 51, with the technical effect. When it went for the final passing in the parliament, after discussion, the parliamentarians removed that provision, making it very simply computer software per se, the business method per se. That means a tremendous amount of legal policy thinking has gone in before passing that sentence. I'm telling you that sentence. So it's not that the law is made one day just like that. Tremendous amount of thinking by a wider section of people have gone in. And this is a law made by today 1.2 billion people. 1.2 billion people. It has its own value, and keeping it its requirement, it has been passed. Now it is definitely laws are changed. The law of the law is constitution. It has been changed 100 times. So this law will also get changed in tune with our development. So in around 10, 15, 20 years, you would see changes happening more towards more liberal patenting. Today, if I look at the scheme of things, it's not as liberal a system of patenting that we have in India as in US. It has come out over a 300 years time. We will be doing that thing along with our process of development. Issues of enforceability has also a link with this. Issues of enforceability also has a link with this. You look at our court interpreting the judgment, a few important judgments regarding drugs, which has come from the High Court or Supreme Court. Final judgment has not come, but they are not given an interim stay like what immediately in the US you get. They did not give an injunction straight away. They said let you go for trial. This is what the Delhi High Court has said. So this is in tune with the scenario, the system that is prevalent in the country. We would be aspiring for that thing. Like in morning, more of innovations, more of things will come. We will graduate towards that level. So the question of enforcement simply cannot be sort of compared between US and India. This is all in single sentence I want to make a point. Simply you cannot make comparison.